Perfect. Hello, everyone. Welcome. My name is Prashasti, and you all know me from the multiple emails you received from me. Welcome and thank you for spending your Friday with us. I'm really thrilled to welcome our fantastic group of panelists who have been spotlighted for your convenience, who will lead us into a really important discussion on immigration and human rights as part of the Immigration and Scholar series. And if you're new here, Immigration and is a new justice-oriented program that is open to everyone. So I'll drop a link in the chat. Today's space is a space of reflection and imagination. So we will start today with welcoming our panelists and then be in conversation with them for about 50 minutes. We will then end with some resources that I'll also send in a follow-up email, so don't worry about missing those. And if you have any questions during this time, I will be monitoring the chat, so feel free to drop those in as well. With that, I will hand it over to Professor Elisa Massimino, who is the Executive Director of the Human Rights Institute here at Georgetown Law, and also my professor, so it's great, we love her, and she will be moderating our discussion today.
Thanks so much, Prashasti. It's great to be here, and I'm loving seeing all these names pop up in the audience, including my new colleague, Olivia Engling at the Human Rights Institute, and at least two of my former colleagues and a former student, Lisa Shaw, who I worked with at Human Rights First, Vanessa Allen, who I worked with at Human Rights First. What a great group. And what a just inspired idea for this series, Prashasti. I'm so thrilled to be involved with this, and I look forward to participating in future iterations of this as an audience member. I want to jump right in, and I have such an easy job as moderator. I'm going to ask each of our speakers to introduce themselves and very briefly, keeping it to 1 minute, and Prashasti's going to put full bios in the chat. These are incredibly prestigious and knowledgeable panelists, so I'm really thrilled to be part of a conversation with them. So with that, could we start off with Sharita Gruberg, and then go to Andy Schoenholtz, Steven Sacco, and then Lindsay Harris.
Thanks, Elisa. I am absolutely delighted to be here for this conversation today. It's a very exciting topic. My name is Sharita Gruberg. I have the privilege of serving as the Vice President of LGBTQI+ Research and Communications at the Center for American Progress, where I get to also work with Elisa, who is one of our incredible senior fellows. In case anybody is wondering why I am in this space as an LGBTQ advocate, well, US immigration law has long been defined by who it's keeping out. And among some of those, for about as long as we've had folks trying to enter the country, it's included LGBTQI+ folks. So, you know, in the early 1900s, even before there were explicit legal barriers to LGBTQ folks entering the country, there was language that blocked, you know, effeminate presenting people from entering, or, you know, the public charge wealth test would be assumed to block certain groups that in effect blocked people who were LGBTQI+, up until the 2010, when President Obama lifted the ban on people living with HIV from coming into the country. So that is, in a nutshell, kind of the main thrust of the intersection of LGBTQ issues and immigration. At a broader point, Center for American Progress is a multi-issue think tank. We have about 20 different policy teams working on a range of issues, and LGBTQI+ team, which is reflective of kind of the organization's approach to issues, is also intersectional. And so we work on just about every issue that the institution works on, because all of these impact LGBTQI+ people in very particular ways. And so excited to join this amazing panel, and more in my bio, I believe, is in the chat. And with that, I will kick it back to Lisa.
Thank you so much, Sharita. We're thrilled to have you. Andy.
Thanks, Elisa. Thanks, Prashasti, for organizing this. It's great to have Elisa moderating it. I'm a prof at Georgetown Law. I direct the Asylum Clinic, CALS, in the fall. I teach immigration law and policy. I do a lot of research on the U.S. asylum system in particular. And it's just great to be here on a panel with my former colleague, Professor Harris, and my former student, Sharita Gruberg. So and on top of that, probably the best thing I've done in the last couple of years is managed to get Elisa Massimino, Professor Massimino, to be our executive director at the Human Rights Institute. So I'm just super happy to be here. Thanks.
Thanks, Andy. I appreciate you. Steven.
Thank you. It's really an honor to be on this panel with so many prestigious scholars. Thank you for having me. I'm Steve Sacco. I am a staff attorney in the Immigration Law Unit of the Legal Aid Society of New York, where I practice immigration law and do deportation defense. I'm also on the board of a little organization called the Free Migration Project. And I'm publishing an article with Georgetown Law, Immigration Law Journal, called Abolishing Citizenship. And so I hope to bring the perspective in that article to our discussion today. My position in that article that I hope to apply here today to our discussion is that the law that should be abolished is the legal distinction itself between foreigner and national, and that it is that legal distinction itself which is inherently racist and anti-democratic. And I'm happy to talk more about that. And it's sort of that perspective and reframing the conversation on migration and migrant liberation around democracy and as a fight for democracy and for a more democratic society that I really want to bring to the conversation and steer us toward. So thank you so much for giving me that opportunity.
Great, we're thrilled to have you and looking forward to reading that article and to your preview of the arguments and digging in on that. Lindsay.
Sure, thank you so much. I'm Lindsay Harris. I direct the Immigration and Human Rights Clinic at UDC Law, which is a HBCU law school, the public law school in DC. And I currently serve too as the Associate Dean of Clinical and Experiential Programs at UDC. I'm really happy to be here. This is a amazing visionary series and really necessary conversations that we need to have to push things forward. And so I'm thrilled to be back virtually at Georgetown, where I did teach with Andy from 2013 to 2015. I am myself an immigrant from the UK. I'm the mum of 2 rambunctious young children. I focus on asylum law and policy, and I have in the past worked on efforts to end the detention of immigrant families. I started out my career working with the African community in the DC area, working with women and girls survivors of gender-based violence. Right now, I'm very engaged with efforts around the Afghan humanitarian immigration crisis. And I'm a founding board member and advisor to Asylum Works, and I serve on the AILA National Asylum Committee. So very asylum focused, and really delighted to be here with you all as we think about the intersection of immigration and human rights. So thank you for organizing this. This is really an incredible series and effort.
Great. Great. Well, thank you again to all of you. And let's jump right in. This is a particularly sad and interesting time to be talking about immigration and refugee issues as we think again about a major forced migration likely to be happening in Europe. And I thought maybe we should start with a little bit of a kind of explainer about the human rights of immigrants. I mean, immigrants are people, obviously, and as such are entitled to the full range of human rights. We tend to think about immigration as, this narrow slice and that there are particular rights just for immigrants, but we, immigrants are entitled to all of the human rights that all humans are entitled to. And then there are some particular legal provisions that recognize rights of immigrants who are in particular circumstances. So Andy, I thought we would start with you, maybe just to lay out kind of the basics of the rights to which immigrants are entitled under international law, and maybe then others can jump in to talk about that framework and whether it's good enough, strong enough, and whether the United States is coming close to living up to it.
Great, thanks, Elisa. As you said, immigrants are people, persons as far as the Constitution is concerned. And that's really where I want to start. And then I'll quickly move to the international human rights laws that speak to the rights of immigrants. And I'm going to focus this where I think the greatest challenges are. But to begin with, the rights of all non-citizens within the United States are protected by the Constitution. That is, if they're within the United States. And the leading case that established that, Yicwo versus Hopkins, dates back to the 19th century. And it held that under the Equal Protection Clause of the 14th Amendment, something all of those on this call know about, states and localities cannot discriminate against immigrants based on their nationality. And those anti-discrimination rights that are in the Constitution are actually at the core of the modern international human rights system that state parties agreed to, starting with the Universal Declaration on Human Rights and the subsequent treaties developed since the end of the Second World War. I want to focus the rights issues, though, with what's been happening for too many years now with regards to asylum seekers who arrive at US borders. So what sort of rights do they have? And there I want to talk about two major rights. First of all, there's a right to seek asylum. And secondly, there's a right not to be pushed back or expelled based on what's become a norm of international customary law, but started as a treaty-based right in the 1951 Refugee Convention. This non-return right is called non-refoulement or non-refoulement, and it is the most important obligation that governments, including the United States, have towards asylum seekers. Governments cannot return or expel asylum seekers to countries where they would face persecution because of their race, nationality, religion, membership in a particular social group, or political opinion. The US actually implemented these rights when Congress enacted the Refugee Act of 1980. So they've been around for a while, certainly during the modern period. The problems that have been encountered, though, is that both Democratic and Republican administrations have violated the US non-refoulement obligations, particularly at our southern border. So I'd like to, if I can, Elisa, say a couple words about that. Is that okay?
Yeah.
Great. So I'm going to focus on the current administration's misuse of a healthcare law that was invoked by the Trump administration in March of 2020 and used very effectively to prevent those who are arriving at the southern border from exercising their statutory and international right to seek asylum in the United States. And the expulsions that I'm talking about are enabled by a highly contested pandemic authority called Title 42 that the Trump administration invoked and that the Biden administration has since maintained. Now, here's the sorry story about it. It's been used more than 1.5 million times to expel migrants. Most of those expulsions have sent migrants across the land border into Mexico, which agreed during the pandemic to take back citizens of El Salvador, Guatemala, and Honduras, in addition to Mexicans. But others have been flown back to their home countries by essentially ICE, Immigration and Customs Enforcement. The Biden administration has already expelled over 1 million via Title 42. Most of those have been classified by Customs and Border Protection as single adults, but tens of thousands of families with children have also been expelled unlawfully in my opinion, and I think well argued in the court so far, under this authority. And I just want to draw attention to one particular group, citizens of Haiti, have been the 5th most frequently expelled after those other 4 nationalities. And unlike those countries, reports indicate that nearly all Haitian expulsions take place by air. Just over half of the expelled Haitians have been families with children. And unfortunately, about a week ago, the Biden administration's 198th flight deporting or expelling people to Haiti marked the 20,000th migrants sent back to Haiti since Inauguration Day 2021. I won't go into more details about this other than to say two more comments. One is the Biden administration has applied Title 42 to nationals of a number of countries: Brazil, Canada, China, Colombia, Cuba, Ecuador, El Salvador, Guatemala, Haiti, Honduras, India, Mexico, Nicaragua, Philippines, Romania, Russia, Turkey, Ukraine, Venezuela, and others. So why is this a violation? There are two ways in which this is a violation of the human rights of those who have arrived at the southern border. First of all, those who wanted to seek asylum. Not all of those who came wanted to seek asylum, but many did. Number one, Title 42 denied them their right to seek asylum. They had no opportunity to make any claim that they would be persecuted if returned to their home country. That in itself is a significant human rights violation. And among those 1.5 million have been refugees who qualify for non-refoulement protection. And that, if you only look at the nationalities involved, there's no question in my mind that some of those who've been expelled in this way have been refugees. At our clinic, our students have represented clients from several of those countries successfully to show that they are refugees. So I just wanted to bring out these are incredibly important rights. And unfortunately, this is a significant area where the US is violating those rights. There are times when the US respects those rights, but not in these situations. I'll stop there.
Thanks, Andy. That's a really comprehensive overview. We have a lot of interesting issues to dive into, but let me pause and see if any of the other panelists want to specifically address this question before we move on.
I just want to make one comment that there's a great deal of literature, obviously going back several decades, along the critical legal studies and critical race theory scholarship that exists, is very critical of the idea of rights language and rights in the law and their ability to actually protect human rights in practice. And that scholarship argues compellingly that actually rights in the law are not very good at protecting rights in practice. And as Andy just pointed out, it's no different in the context of migration. And so I think as a response to that problem, and with the law actually having the impact it's supposed to, a lot of scholars and activists have developed abolition and reparations as a response to that problem, as a way of really redistributing power and building equity in practice in a way that rights language in the law is not so effective at doing. And so I think we want to have more talk about what W.E. Du Bois called abolition democracy and less talk about human rights in the law to actually redistribute power and equity.
Thanks, Steve. Sharita, one of the fundamental tenets that undergirds all of human rights law and the framework is the principle of non-discrimination, that all people are entitled to these rights by virtue of their humanity. And yet, so much of our immigration policy in the United States, going back to the beginning of time, is really an exercise in discrimination. And I wonder, given your expertise and your work at the intersection of immigration and LGBTQ people, if you could talk a little bit about the experience of LGBTQ plus people seeking protection, seeking to move, and how our own immigration system in the United States is working or not to protect those vulnerable people.
Sure. Well, there's close to 80 countries where same-sex relations are criminalized, but that doesn't really capture the full extent of places in the world that it's just very unsafe to live openly and authentically as an LGBTQI+ person. For example, in the Ukraine and Russia and Chechnya, it's not explicitly, well, except Chechnya, it's not explicitly criminalized. However, there's been a slate of legislation enacted that in essence drives people underground. So for example, we've seen a lot of news in the US recently on the Don't Say Gay law being put forward in Florida. But these types of legislation really originated in Russia with these types of bans on even acknowledging the existence of LGBTQI+ communities. And so we're seeing this kind of erasure of identity in addition to criminalization. And then in places like Honduras, where they decriminalized same-sex relationships back in, I think, the 1890s, it's still one of the places where we have the highest rates of killings and violence against LGBTQI+ people, particularly transgender women. And so there's also this not just generalized violence, but kind of a permissiveness of state actors to violence that's not enacted in the legal code, but has this lived impact on people's lives. And what is the real impact on LGBTQI+ folks? It's a decrease in places that are safe. So when you're looking at migration patterns, where you're looking at where people are going, for LGBTQI+ migrants, it's not safe to go to the country next door because the odds are your identity and your safety are still criminalized or at risk. So, you know, we're seeing so many LGBTQI+ refugees in Kenya who are not safe in Kenya. Most notably, we've heard reports of some pretty atrocious attacks and violence and killings against LGBTQI+ refugees awaiting resettlement in Kenya. For folks escaping really violent conditions and a lack of government willingness to uphold or ability to uphold their rights in Central America, we're seeing folks, as Professor Schoenholtz alluded to, are trapped on the southern border in Mexico. And again, you know, we don't have these legal barriers for LGBTQI+ folks, particularly in Mexico City and some other places where they even have marriage equality. However, we don't have protections, we don't have safety, and we have really high rates of attacks. So for the LGBTQI+ migrants seeking protection who are in the southern border trapped because the so-called migration protection protocols have an exemption for LGBTQI+ folks. So the administration has realized, like, this is a community that's at risk in and a way in to seek asylum. Title 42 has in essence trapped them, and the implementation of that has trapped them at the southern border. So there's not a path forward to seeking protection, and they're just in this space where they're facing attacks, assaults, kidnappings. And as Professor Schoenholtz also mentioned, it's not just Central Americans. We've got Jamaicans, we've got Haitians, we've got Russians and Chechens, people basically from all over the world who haven't had another pathway into the US and have sought it through the southern border, are now trapped in camps. And so, you know, for LGBTQI+ folks, as with so many populations, this right to seek asylum has not actually been upheld in any meaningful way.
Yeah, that's thanks, Sharita. It's a grim situation where, you know, again, as Steve said, rights on paper are, you know, honored in the breach in so many situations. I know that, you know, one of the things we want to explore here is the way that immigration systems actively undermine the whole concept of human rights that are inherent in all of us. And so many of the asylum and immigration laws require quantifying and, in a way, sensationalizing pain that people have experienced that have caused them to flee. All kinds of pain, whether it's, fits into the refugee definition or not. And I wanted to turn to Lindsay to ask, how can we address that from a human rights perspective and create some trauma-informed spaces for people to share their stories without being exploitive or without, reinforcing this very damaging trope about, good immigrants and bad immigrants, and that people have to check, a bunch of boxes in order to be considered worthy of human rights?
Yeah, thank you, Elisa. That's such a good question. And I think it's one that so many of us working in this field wrestle with very often. And the way that our laws are written and the way that the system is set up requires very often a really deep dive into traumatic experiences. So, to start with asylum, individuals have to show, we're probably all very familiar with the asylum definition, but that they've suffered persecution in the past, or they have this well-founded fear of persecution in the future. The strongest case is going to be one where you have both. So you want to dive into all those incidents of past harm. Asylum law, requires you to establish a nexus to a statutory ground, which means basically you have to get into the very minute details of the harm that the person has endured and how and why you were harmed. So I think, like many of us, I often say to asylum seeking clients that I'm standing alongside in this process, that this requires revisiting the very worst moments in your life over and over again. And many of us know that this is contrary to how the brain actually processes trauma, of course, where we know that traumatic memories are actually literally stored in a different way and can be harder to retrieve. And often our ways of coping with trauma are to avoid discussing it or anything that triggers it or makes us think of the traumatic event. So, the credibility standards for asylum law, which were underscored and made more intense by the Real ID Act of 2005, means that we need that excruciating detail. But at the same time, doing that, right, as a zealous advocate, as somebody who's represented hundreds of asylum seekers, you often worry that doing a deep dive and detailing a traumatic event, a rape, for example, somehow kind of raises the bar for other asylum seekers, or it becomes the kind of trauma Olympics. I think another really good example, just to touch on one more before I talk about kind of what we do about this, right? And how do we try and create trauma-centered spaces? I like the term trauma-centered, which was given to me by Malika Kerr, who's a colleague of mine at Berkeley. And she thinks that trauma-centered really helps us to not just kind of take trauma into account as a side issue, but to really center it in the way that we are working in our own trauma exposure, our own responsibility to be good stewards of our own trauma and what we're exposed to, and in working with clients. So I think another really good example is the U visa, right? Set up by Congress to try to incentivize undocumented immigrants to cooperate with law enforcement in the investigation and prosecution of certain crimes. Here is where that concept of the good versus bad immigrant, and that always makes me think of Liz Keyes at Baltimore, wrote a great piece years ago now, Beyond Saints and Sinners. I think it was published in the Georgetown Immigration Law Journal, I think. And, thinking about this like dichotomy of good and bad and these very black-white ways of thinking about things. But for the U visa, the applicant has to very much step into and almost claim the role of victim. They have to show substantial physical or mental harm as a result of the crime. And so you're in this position as the advocate of painting the victim as good and the perpetrator as bad. And these cases often, right, are causing you to do some really intense reflection on the highly racialized and problematic nature of our criminal justice system. So I won't say that I have found a way to reconcile all of this. I do think what Steve said about thinking about immigration abolition and adopting a deportation abolition ethic, which is something Leila Khlas at Tulane talks about. She has a forthcoming California Law Review article, and I know you're doing an immigration and abolition talk in the series. What I will say is that, the people that you're working with, right, your clients, but those you're standing alongside as an advocate, have to actually be informed as to the stories you're telling about them and the way that you are framing their story and why. And ultimately, how the story is told is up to them. There are so many ethical issues that arise, right? For example, back to my U visa example, if you have the victim of a crime allegedly perpetrated by, let's say, a Black man, what responsibility do you have, and does that client of yours have, not to kind of further this narrative of the dangerous Black man? And then at the same time, you have to zealously represent your client, and that may benefit their case. So there's no hard and fast answers. I think acknowledging the problematic systemic issues with immigration and our very biased racist system for my clients, and explaining to them, right, this is not how I think the system should be. This is the reality. How do you want to navigate that? And giving your clients that agency, kind of power and control over things. And then finally, I think I would say that part of all this is managing our own trauma exposure and response. So I wrote a very long article on this, asylum attorney burnout and secondary trauma, and kind of put forward a bunch of things that I think we need to do in terms of a fundamental shift in law schools and how we train people not only to think like lawyers, but actually to deal with the emotional realities of being lawyers. I think we do need a pretty big sea change, and we're starting to see some of that in how we think about lawyering and the emotional responses we may have to lawyering. So recognizing we all come to lawyering with our own experiences. I identify myself as a trauma survivor. I'm sure many other folks do. Every day I work with folks who have gone through traumatic experiences, many of whom are still living in the trauma, especially right now with Afghan individuals seeking protection here or advocating for their families to come. And so we have a responsibility, right, to think about how we actually manage and navigate our own responses to trauma as one piece of this.
Thanks so much, Lindsay. That's so thought-provoking. And I know that each of the other speakers probably has some experience with this phenomenon personally, either representing clients or making adjudications and even making decisions about clients to represent. I wonder if anybody wants to jump in on that. Andy, I know you've got to be in a position of actually helping to train the next generation of lawyers to do this work as they're doing it. Did you have any thoughts you wanted to add to that?
Sure, I'd be happy to. And then I'd love to hear from Sharita and Steve as well. And of course, I've learned a certain amount from Lindsay on this because we work together. And a few of our CALS alums are here. I see at least Shaw, Lisa, and Bintu, who've experienced this. So, there's this, when you're thinking about the humanity of our clients and the people we're trying to serve, the rights of whom we're trying to protect, the intimate relationship that we try to help students develop, and it's really they're the ones in charge, they're developing it, but we're advising them on how to best develop it, is really to do what they can to empower the client. And what that really means is confronting really difficult issues like the trauma that they've experienced, if we're talking about those who've been traumatized or been tortured or both. And that's, how do you do that best? How do you, number one, build the trust of a client? This is really one of the things I think is so rewarding and so difficult about asylum representation, is this tremendous intimacy and you're really asking permission to develop that intimacy with the client. I never would have thought about lawyering in this way when I was in law school. That nobody ever talked about this whatsoever, but that's really what it is. And I think one of the tools that can help is naming things and talking all of those issues through. You need to not only be aware about your own secondary trauma being experienced through your work with those who've you're representing, but particularly how not to recreate the trauma for them. And the unfortunate situation, as Lindsay described, is right now in the law, we're stuck with this system. And I hope that there are reformers who help us get well beyond this. I think that would be wonderful. But in the meantime, it's the role of the lawyers is to try to then, work through that with their clients, help them understand why, and listen to their clients, understand when it's not a good time to be talking about any of this, and giving them the space. Empowering them means they play the role of what they feel is most appropriate, and how they can deal, and they're the ones who know how to deal with their trauma best. And the second thing is also, helping them with any services that might be helpful to them in dealing with their trauma, particularly psychological services. I'll stop there.
Thanks, Andy. Sharita, did you want to jump in on that?
Yeah, and Andy.
Oh, we lost your audio, Sharita.
Got lost again. Okay. Professor Schoenholtz just reminded me of another aspect of this, and that is the 1-year filing deadline for asylum cases. We're talking about trauma, and we're talking about trauma response and how people are recovering, and how do you square that with the government basically giving you a clock to apply for asylum when folks are fleeing trauma? And for LGBTQ plus folks who have had to spend their entire lives and their survival has based on not being out and open with government officials, there's that added layer of complication of, you now have a year to, when you're fleeing, when you've spent your life in the closet because your survival depends on it, to have to out yourself in this very invasive way to be able to survive and get the protections that you need. And I'll drop in the chat, I had the opportunity of working with Human Rights First on studying bars to asylum, and LGBTQI plus folks, asylum seekers, were more likely to be rejected because of the 1-year filing deadline. And again, when you're talking about trans folks, we found trans asylum seekers were more likely to have a defensive claim than an affirmative claim. And we also found that affirmative claims had higher success rates. And so why is this? Well, if you're transgender, you're in a country where you haven't been able to access medical transition services in a lot of cases, and your safety could be at risk if you socially transition. And so that's, hair, dress, physical appearance. You come into the US, and a first priority for a lot of folks is survival. And for trans folks, being able to live authentically is so critically tied to survival. And so and it takes time for folks to be able to access care and services that folks need to be able to live authentically. And that's a survival thing. That is first step, what you need to do. And then you can think of even applying for asylum.
Yeah. It's I want to turn to you, Steve, to kind of tie all of this together, because I think what we're hearing in different ways from each of the speakers is how, in practice and in some ways in theory and in the law, that the system for acknowledging and protecting the human rights of people on the move is, in many ways, seems designed to undermine their fundamental human rights. And so, how should we be thinking about this system that we are operating in as lawyers and with our clients, when the system itself is the product and the concept, really, I think as you'll spell out, of nationalities and borders is so much bound up in the history of discrimination, colonialism, racism, I learned from one of my students in my class about Native tribes on the southern border that are separated by that border. They're one nation of Native people, but immigration law makes it impossible, and the implementation of the law makes it impossible for them to be part of, to visit their sacred sites, to be part of their tribal rights and all of that. So something that, I had never even focused on, and I've been working in this field for 30 years. So could you talk us through maybe a different vision that cuts through some of these problems and how it would work in practice?
Oh, that's a very big question. Well, let me start by saying, I think as Lindsay described, I think our role as immigration lawyers, as deportation defense lawyers in the deportation system, is really about harm reduction. We can mitigate trauma, but we can never eliminate it. Because the citizen non-citizen distinction in the law is a caste system. Ultimately, it's literally a caste system in that you have two sets of legal rights, one inferior to the other, and that the superior set of rights benefits from the subjugation of the other. And there's no way to make that system fair or non-racist because it's the opposite of equality. And so there's no way to make it non-traumatic either. So all we can do is mitigate the trauma rather than stop it in the ways that Lindsay described. And we talk about sort of the good immigrant, bad immigrant narrative. And I think the only way for us, I think as advocates and practitioners and scholars, to really destroy that narrative, I think is to take unequivocally and unambiguous positions against borders and deportation and internment. I think we have to, in the places where we have voices, condemn them in very clear terms. I mean, we have to treat them and think of them the way we think and treat, the way many of us think and treat things like capital punishment or torture. That these are things that are beneath civilization, that have no place in a civilized society. And when we take these positions and we advocate for the abolition of these inherently racist and anti-democratic and threatening to democracy institutions, then there can be no bad migration within that framework, and therefore there can be no bad migrants. I think that's the only way we can really, resolve that problem in our discourse. And I think on a policy level, the short answer to what we should be doing as attorneys is that we really should embrace abolitionist and reparationist positions. It's often been said that abolition is not just a goal but an organizing strategy. That's the catchphrase of brilliant people like Miriam Kava, for example. And I think for lawyers, it should also function as a career path. And a guide around what policies we should support and what policies we shouldn't. We all have limited energy and limited resources, and abolition as a goal, directs us as to where to put those limited resources and energies. And Ruth Wilson Gilmore talks about the difference between reformist reforms and non-reformist reforms. The reformist reform is the changing the curtains on the hotel rooms on the Titanic. It's arranging the chairs on the deck of the Titanic, I think is the correct metaphor. It's not actually going to get us to abolition. But non-reformist reforms are changes to the law that at least are consistent with an abolitionist goal. So for example, very popular issue right now in immigration law is the passage of law that would give us independent immigration courts. Article 2 courts. This is put forward as a good reform, but it's not abolitionist. It's the opposite of abolition, because it's just creating an institution that we would hope to abolish again in the future anyway. And the fantasy that this will make things more fair is unfounded, because the problem is still there. This distinction between foreigner and national is still there, and so it can't possibly be fair. You're just trying to improve on the caste system, which is impossible. And so instead, a non-reformist reform would be something like closing an ICE detention center or closing an ICE internment camp. That would be something consistent with abolitionist goals, or embracing non-citizen suffrage at the municipal or state level, as New York City just did, passed legislation that would allow, unfortunately not all, but some non-citizens in New York City to vote in municipal elections. That sort of change at the local level or at the municipal level is consistent with a post-citizenship or post-border world. And I think that in as much as we as lawyers have a voice in policy, it's our obligation to support those positions and to support those policies. And, you know, again, I keep talking about reframing this conversation is not just about immigrant rights or about even the right to migrate, but around abolition democracy and around building an anti-racist democracy. And what institutions do we have to raise to the ground in order to get us there, like citizenship or like borders? There's this, you know, amazing Leela Watson quote that I'm sure you are all familiar with. You know, that if you've come here to help me, you're wasting your time. If you've come here because your liberation is bound up with mine, you know, let's work together. I think that quote really captures, you know, why we want to reframe this conversation, because it not only, you know, helps push away white saviorism, but it also reminds us how high the stakes are. That this is not just about citizens like me helping non-citizens. This is about all of us trying to build a freer society. Because in the end, when our society is less free, we're all in danger and we're all oppressed. So I think ultimately, you know, that's why I'm interested in having this conversation around the ways in which, you know, the foreigner and national distinction in the law undermines liberty and equality and you know, other democratic institutions.
Thanks. It's such an interesting and provocative idea. You know, I think about the, you know, the kind of establishment of the kind of international human rights framework and how so much of it is premised on, you know, the concept of states honoring the rights of individuals. And so much of refugee law is premised on, you know, the initially for individuals to enjoy their human rights within the context of their own, you know, country of citizenship, and that they have claims on other states for protection when that fails. So much of it is premised on an idea that itself is, you know, shot through with all kinds of problematic history. So it's really a very provocative proposal and idea. I don't know if anyone, we have about, I guess, 6 or 7 minutes or so to engage with the audience for questions or engage with each other on any of these points. Prashasti, do we have any questions from?
There is one question about how abolitionist goals interact or are furthered or hindered by the international human rights system.
Maybe Steve, you want to start with that?
Sure. Well, I think as we touched on, you know, well, I mean, first of all, the whole international law and international human rights system is built on this idea of national sovereignty for each nation state, which is at the crux of the sort of citizen, non-citizen caste system, because it's speaking specifically to the law of the United States, our federal law created the idea of national sovereignty out of whole cloth in the 19th century in an extra constitutional way, entirely to preserve white supremacy and ultimately white nationalism in the United States. Sovereignty was just a proxy word for the right of a white republic to stay a white republic. And every immigration law that follows from that jurisprudence is ultimately premised on that idea. So a human rights system that is based on a collection of white republics that have the right to stay white republics is inherently racist, obviously, but also can never truly afford human rights in any meaningful way. That's why there's no right to migrate under international law. That's why the only exception to national sovereignty under international law is the asylum framework, which is already kind of a dead letter in many circumstances. And I think that's the answer that comes to mind to your question. But I'm happy to. I'd like to hear from others and what they think about that particular question.
Anyone want to weigh in on that? I do want to maybe stand up a little bit for international human rights law and framework, in part because while acknowledging many of the kind of inherent flaws of that system, kind of constitutional, if you may, and the flaws of that system from the very beginning, that there are millions and millions of people around the world who turn to that framework as a way to protect themselves and advance rights in their own society. So I want to be very cautious about, referring to it in any way as a, kind of window dressing or the curtains. But while also acknowledging the distinction, I think the correct distinction that you made, Steve, about the reform-minded reforms and the one, I can't remember the formulation that you made, but essentially, and we talk about this, Prashasti knows this in our class about, is it possible to pursue protection inside of a system that is fundamentally illegitimate? And how do we do that? Because, those, rearranging the deck chairs activities that we lawyers do often save lives of people who are in front of us right now. And you're doing that every day. And I know that students and all of us feel very much challenged by the tension there. I don't know if Lindsay, Andy, Sharita, you want to weigh in on that at all?
Yeah, I'll just add. I think Steve's put his fingers on a major problem in our international human rights system. I mean, it's based on the Treaty of Westphalia and the nation-state system, and so that's a problem. It was a problem in negotiating treaties. I don't know if you all know, but the Universal Declaration for Human Rights, which of course is not a treaty, it's the Declaration of Principles, we came this close to having a right to asylum, not just to seek asylum. 7 votes. And by the way, Australia was on the side of those who supported a right to asylum. Now, yes, things changed. So it's absolutely problematic. And I think I like your idea of the non-reform reforms, that how you really can make a difference within and challenging that system, I think is really important. I also recognize exactly what Elisa's saying, because I was pointing to the faults, the problems in the asylum system. When I began the talk about human rights today, the other side of it is, and every day, government officials use those laws to actually recognize and protect people who need protection. The problem is, I'd like them to do a much better job of it. And I can imagine, and I think it's great to try to imagine a universe where we have, no discrimination in our laws, where we don't have the assumptions, as Steve's pointed out, that are part of the problem here.
Lindsay?
Yeah, I just echo Steve's thoughts. I love this concept of, reformist reforms versus non-reformist reforms. And that's a lot of that. My thinking on that has come from Angelica Charzaro's work and then the work of Leila Halas, as I mentioned. I think so many of the things we're doing You know, it's kind of, we all used to describe family detention centers in immigration as lipstick on a pig, right? Like if you were kind of working on conditions to make things a detention center more family friendly or child friendly, you know, do we want the kids to have crayons in school while they're being detained? Yeah. Do we want them to be detained? Absolutely not. I mean, the same goes for all conditions in all immigration detention, right? We want to abolish the whole system. So I think it's a real tension though, right? While we are improving things, like I do think that independent immigration courts would be better than what we have now, right? Do I think that bringing down, you know, abolishing kind of immigration deportation in general and really doing a giant overhaul of the whole system would be better? Yeah, but I think it's something that, you know, previously without these lenses to think through, or as they become more mainstream, right, in advocacy circles, previously, not all of us were taking that into account. I certainly have not throughout my career, right, always taken these things into account. And so I think as long as we now are doing so and working through, I think there's a great four-step framework that Angelica Cesaro puts forward. I think we're going to move forward in a positive way, right? Not to say that some progress is better than no progress, but I think having abolitionist ethic in mind is going to help us move forward and make things better for as many human beings as we can.
Absolutely. Sharita, do you have anything you want to add to that? Oh, that's okay.
Technology issues. Yeah, I mean, this reminds me, you know, in the LGBTQI plus rights movement, there's this argument about, you know, is our goal assimilation or is it liberation? And the marriage equality fight really encapsulates that, where you have these rights and we were kept out of it, but is that the limit of what we're trying to achieve here? Are we trying to go against equality and go towards, you know, separating our rights and our liberation from state grants? And so this is constantly a struggle. We are in this system. We are in these spaces where we have urgent, immediate needs of the folks in our community, but how do we hold that while trying to move beyond these limits? And I think, you know, Steven had some really great examples. And I think that for me, what really resonated was that harm reduction approach. What we're doing is harm reduction. And how do we hold that immediate need for harm reduction for communities while not letting that limit us in striving for liberation and striving for a world without borders and where our rights are not tied to these issues where we're seeing every single day how the current structure is failing the folks most in need.
Yeah, yeah. Well, gosh, this has been such an amazing conversation, and I feel like we could go on for another hour at least digging into these issues, but we're at the end of our time, and I just want to sincerely thank all of you for being with us today, and especially thank our speakers who took time out of very busy lives without being paid and during a pandemic to share their perspectives with us and enrich our understanding. I am very grateful for Prashasti and all the folks at the Immigration Law Journal and all the co-sponsors of this series. Fascinating, really groundbreaking. And I encourage all of you to look at the previous ones and tune in again for the next one, which I think is Immigration in Black Lives, which I think will be really fascinating. The speaker lineup is outstanding. Just a reminder, I think Prashasti is sharing a lot of resources in the chat. I know that I'm coming away with new insights and perspective from all of these amazing speakers. So thank you so much all for joining us. Have a great weekend, a great rest of your day.
Great to see everybody. Thank you all.
Thanks.
Thanks so much.
Thanks for having me.
Thank you, everyone.